Picture this: you are 72 years old. You have resided in your house for 31 years. You have cleared the mortgage completely. You brought up your kids there. Every section of that house contains a memory. Then one morning you experience a stroke. You make it through, but you are unable to talk. You are unable to write your signature. You are unable to reach decisions. Your daughter hurries to the bank to settle your property taxes before the cutoff. She enters the building. She provides them your name, and the bank informs her, "We are sorry, you possess no legal power regarding this account." Your daughter is unable to pay your bills. She cannot reach your accounts. She cannot sell, refinance, or even upkeep your house. Everything becomes locked and the bills continue arriving. This is not an unusual situation. Based on the Consumer Financial Protection Bureau, this occurs to households each single day throughout America because five basic papers had never been completed. I'm Joseph, and this is Wise Life America, and I serve as the Senior Policy Analyst focusing on retirement economics, Social Security regulations, and the lawful safeguards that exist especially for individuals over 60. Today, I will guide you through the five most vital documents every house owner over 60 needs to complete before it becomes too late. These are not views. These are not online hearsay. Every single detail I am going to present comes straight from official government materials. I refer to the Consumer Financial Protection Bureau, Medicare.gov, the IRS, the Social Security Administration, and AARP verified studies. Now here's why you should remain until the complete end of this video. There is a concealed tax issue, and I will describe it in document number 5 that can cost your kids hundreds of thousands of dollars in capital gains taxes, and it relies on one particular choice you make about your house while you are still living. Most people have no idea this issue exists, but by the end of this video you will. So let us start. Let me describe Robert to you. Robert was 67 years old. He was a retired electrician living in Ohio. He owned his house without any debt, no mortgage. He had a modest pension, his Social Security payment, and a small savings account. Robert saw himself as a responsible person. He had informed his two adult children, David and Karen, exactly what he desired. The house would transfer to Karen because she lived close. David would receive the savings account simple fare. He told them this over Thanksgiving dinner in 2023. Everyone nodded. Everyone agreed. But Robert never put it in writing. He never signed a will. He never submitted a power of attorney. He never arranged a transfer on death deed. He thought the kids know what I want, that is sufficient. Then in early 2025, Robert had a serious fall. He struck his head. He developed a brain bleed that left him unable to make decisions. Karen went to his bank to pay his property taxes. She was denied access. She called Social Security to handle his benefits. They told her she had no power. She tried to organize home repairs so Robert could eventually return home from rehab, but she could not sign agreements on his behalf. David meanwhile hired a lawyer and asked the court for guardianship, and suddenly Karen and David were no longer agreeing. The court became involved. Legal costs began to accumulate. Robert's house remained empty for 11 months. Property taxes remained unpaid. A lien was put on the house. 11 months, no power, no strategy. The house was nearly lost. All of this, every single part, could have been avoided if Robert had completed 5 documents. Let me reveal what they are. Document number 1, Durable Financial Power of Attorney. This is the single most vital legal document for any house owner over 60. A durable financial power of attorney provides a person you trust. They refer to this person as your agent. The legal power to make financial decisions on your behalf if you become unable to act. That encompasses settling your home loan, overseeing your bank balances, dealing with property taxes, even disposing of your house if required. Now, focus carefully on the term durable. According to the Consumer Financial Protection Bureau, a standard power of attorney actually ceases functioning the instant you become unable to act. That is the precise instant you require it the greatest. A durable power of attorney stays active even after you lose the capacity to make decisions. Here is the issue most individuals encounter. Many older adults think that their partner or their grown child can immediately take over and manage their finances. The CFPB is quite clear on this matter. That is incorrect. Without a proper durable POA, no household member possesses lawful power to proceed. Not your wife, not your husband, not your son or daughter. And without it, your household has only one choice, requesting a court for guardianship or conservatorship. The CFPB describes this procedure as prolonged, costly, and quite open. AARP indicates that conservatorship cases can result in household disagreements, rival requests, and the court not your household, determining who manages your life. One additional essential matter, the Social Security Administration currently provides something known as Advanced Designation of Representative Payee. This permits you to designate up to 3 individuals who might handle your Social Security payments if you ever become incapable of doing so yourself. You can establish this immediately through your My Social Security account online at ssa.gov. I highly suggest you do this immediately. Document number 2, Last Will and Testament with particular home specifications. Now, let us discuss your testament, and I do not simply mean any testament. I mean one that particularly deals with what occurs to your house. According to the Consumer Financial Protection Bureau Authorized Guide for Older Citizens, a will is the lawful paper that outlines your desires for what occurs to your assets when you pass, including your house. Here is the misunderstanding. So many older adults think that informing their household what they desire is sufficient. It is not. Without a proper written will, your house transfers according to your state's inheritance laws without a will. That means the state, not you, determines who receives your house, and the state's method may give your home to individuals you never planned. AARP states it clearly without a will. It's up to state laws and probate courts, which can lead to unnecessary time and expense. This can produce what AARP calls complicated titles. That means the individual residing in the home is not recorded as the lawful proprietor. They cannot dispose of it. They cannot remortgage it. They cannot protect it. In certain situations, they cannot even perform basic fixes. And here is the expense. AARP calculates that probate without a will can require over a year and cost more than 3% of the estate's overall value. On a $1 million estate, your successors could lose over $30,000 just in probate costs. Do not allow that to occur. If you are over 60 and you possess your home, you require a will. And if you already possess one, take it out and examine the date. If you created it before a significant life occurrence, a separation, a passing in the household, the arrival of a grandchild, it may require updating. Free lawful assistance is obtainable for individuals over 60 through the Elder Care Locator at 1-800-677-1116. Document number 3, transfer on death deed or revocable living trust. Now, this is the paper that most older adults have never learned about, and it could be the most effective one on this list. A transfer on death deed, also known as a TOD deed, is a lawful paper that states when you pass, your home transfers straight to the individual you designate. No probate, no court, no delay. According to the CFPB, it is easier and cheaper to establish than a trust. As of 2026, roughly 30 states, the District of Columbia, and the U.S. Virgin Islands permit TOD deeds. You submit it with your local recorder of deeds and you maintain complete control of your home for as long as you live. You can modify it or revoke it at any moment. Now, if your state does not permit a TOD deed, the option is a revocable living trust. According to consumerfinance.gov, a living trust allows you to move your home to a trust that you manage during your lifetime. You are your own trustee. When you pass or become unable to act as successor trustee, you previously designated takes over again without proceeding through probate. But here is the vital issue. Many individuals establish a living trust and believe they are finished. They are not. The Consumer Financial Protection Bureau is quite particular about this. A living trust is useless until assets are actually moved into it. That means you must change the title of your home in the name of the trust. If you omit this step, your home still proceeds through probate, even though you paid an attorney to establish the trust. Also, the CFPB cautions that trusts are occasionally promoted by dishonest persons and companies. If anyone contacts you proposing to establish a trust, please verify their credentials thoroughly and consult with an independent lawyer first. And one additional matter that is completely vital. According to Medicaid.gov, state Medicaid programs must, by federal regulation, to pursue recovery of payments from the estates of persons age 55 or older for nursing home and home care services. States can even put claims on your home during your lifetime if you are permanently in a facility. However, and this is significant, states may not recover from your estate if you are survived by a spouse, a child under 21, or a blind or disabled child of any age. So, comprehending these regulations before you make any transfer choices is vital. Document number 4. Advance Healthcare Directive. This is the paper that safeguards your physical well-being, not simply your bank balance. According to Medicare.gov, an Advance Healthcare Directive contains 2 sections. Part 1 is a healthcare proxy, occasionally called a durable power of attorney for healthcare. This designates someone you trust to make health choices if you cannot speak for yourself. Part 2 is a living will. This outlines which treatments you desire or do not desire if your life is in danger. We are referring to items like dialysis, breathing devices, revival, and tube feeding. It also notes whether you want to donate your organs or tissues. Now here's the issue. Many older adults think that their financial power of attorney includes medical choices as well. It does not. The Consumer Financial Protection Bureau makes this quite clear. A financial POA and a healthcare directive are 2 entirely distinct papers. You require both. And here's another error individuals make. They create the directive, but they place it in a storage cabinet and never inform anyone. If no one knows the location of your directive during a crisis, it might as well not be there. You need to provide copies to your physician, your medical center, your healthcare proxy, and your household members. And here is some positive information. Medicare covers advanced care planning conversations at no expense to you when it is included in your yearly wellness appointment. So the following time you visit your doctor for that annual examination, mention this. Request them to assist you. Place your desires in writing. You possess the lawful right to do so. Medicare.gov particularly states you have the right to carry out your plans as you choose without discrimination. AARP has indicated that the lack of a healthcare directive is one of the main reasons households end up in conservatorship cases. Do not subject your family to that. Document number 5, homestead exemption, senior property tax exemption application, and now we arrive at document number 5. This is the one that saves you funds each and every year, and it includes the concealed tax issue I promised to describe to you about. Most states and many municipalities provide homestead exemptions or senior property tax exemptions. These programs decrease the taxable worth of your home, which reduces your property tax invoice. Some states also provide tax freeze programs that limit how much your taxes can rise year to year. But here is what surprises people. These exemptions are not automatic. AARP is quite clear about this. You must submit an application with your local county assessor or tax office. And in many locations, you have to renew it each year or every several years. AARP quotes one specialist who says anybody can forget to fill out the renewal notice, especially older adults who get a lot of junk mail. If you miss the deadline, you pay full price. And over 10 or 20 years of retirement, that can add up to tens of thousands of dollars you simply threw away. On the federal side, the IRS now provides Form 1040-SR, which is a senior-friendly tax return with larger print. And beginning with the 2025 tax year, there is a new enhanced deduction for seniors for taxpayers, 65 and older, according to IRS publication 554. If you are considering selling your home, remember you may be able to exclude up to $250,000 in capital gains. That is $500,000 for married couples filing jointly. The home just needs to have been your primary residence for at least 2 of the last 5 years. That comes directly from IRS publication 523. Now here's the concealed tax issue I cautioned you about at the start. And this is the one that can charge your family the most funds. If you transferred your home to your child as a present while you're living, your child receives your original cost basis. Let me place that in actual figures. Say you purchased your home for $50,000 40 years ago. Today, it is valued at $400,000. If you gift it to your son, his cost basis is $50,000. When he sells that home, he owes capital gains tax on $350,000. But if you retain the home in your name and he inherits it after your passing, something quite different occurs. Under IRS Section 1014, the cost basis steps up to the fair market value on the date of your passing. So his basis becomes $400,000, and if he sells it for $400,000, he owes zero in capital gains taxes. That one choice gift versus inheritance could be the difference between your child maintaining their financial stability or losing a huge portion of it to taxes. This information comes straight from IRS Publication 551 and the IRS Gifts and Inheritances FAQ page. Please consult with a tax expert before you transfer your home to anyone. All right, you now understand the 5 papers. But understanding without action alters nothing. So here are 3 specific steps I want you to take this week. Not next month, not sometime. This week. Step 1, collect and submit your 5 papers. Sit down at your kitchen table with a pen and a notepad. Go through this list. Check off which papers you already possess. Circle the ones you're lacking. Number 1, durable financial power of attorney. Number 2, a last will and testament with specific instructions for your home. Number 3, a transfer on death deed or a revocable living trust. Number 4, an advance healthcare directive, including both a living will and a healthcare proxy. Number 5, your homestead or senior property tax exemption application. If you are lacking even one of these, you have a gap. And gaps cost households their residences, their savings, and their peace of mind. For the papers you need assistance creating, call the Elder Care Locator at 1-800-677-1116. This is a free government-funded service for people over 60. They will connect you with free legal assistance in your area. That number, again, 1-800-677-1116. Step 2. Share your papers with the right people. Completing a paper and placing it in a drawer is not enough. Your durable power of attorney needs to be on file with your bank and your financial institution before an emergency happens. Remember, the CFPB warns that banks may reject a POA they have never reviewed before. Do not wait until a crisis to find this out. Your advance healthcare directive needs to be in the hands of your physician, your medical center, your healthcare proxy, and at least one other trusted household member. And while you are at it, log in to your My Social Security account at ssa.gov and set up your advance designation of representative payee. Name up to 3 people you trust. This is free. It takes just a few minutes and it can prevent a nightmare. Step 3, review and update everything once a year. Life changes. People change, laws change. The person you named as your agent 5 years ago may no longer be the right choice today. The will you wrote before your divorce may send your home to someone you never intended. Set a date once a year, maybe your birthday, maybe the first day of the new year, and review all 5 papers. Make sure they still reflect your desires. Make sure the right people still have copies. Make sure your property tax exemption has been renewed. This one annual habit could be the single most important thing you do to protect your home and your family. Before I let you go, I need to say something important. What I just shared with you in this video, it could change the outcome of your retirement. It could protect your home. It could save your family from court battles, tax penalties, and financial heartbreak. But here is the reality. The government does not send you a reminder to complete these papers. There is no alert that pops up on your phone when a new rule changes, and YouTube notifications, they are unreliable. The algorithm decides what you see, not you. That is exactly why I created something for you. But more than that, this channel sends you real-time alerts whenever there is a change to Social Security rules, Medicare policies, pension laws, banking regulations, insurance updates, or travel rules that affect seniors. No spam, no ads, just clear, verified, urgent information delivered directly to your phone so you are never caught off guard. Click the link in the description right now. Join the channel, download your free guide, and share this video with someone you love who owns their home and is over 60. Because the 5 papers we talked about today, they do not help you after the crisis hits. They only work if you complete them before it is too late. Wise Life America. Thank you for watching. I will see you in the next one. Stay safe, stay informed, and take care of what you have built.